Welcome to
Okay.
Worcester Historical Museum's Pretty Powerful 100 Years of Voting and Style program series, presented this evening in partnership with League of Women Voters of Worcester Area. I'm Ann Sadek, Director of Development at Worcester Historical Museum. This evening's talk, After Suffrage, the campaign for the Equal 1920-2020, is the third program leading up to the museum's major exhibition, Pretty Powerful, 100 Years of Voting and Style. Pretty Powerful will celebrate the 100th anniversary of women's right to vote through fashion and the changing roles of women. We are looking to make a powerful statement. The exhibit will celebrate a century of women's social and political activism in Worcester and beyond. This evening's agenda will include a 40-minute talk and 10 minutes of Q&As, estimated to begin at 7:45. Please enter your questions into the chat box as you think of them, and I will queue them up for Barbara. It's now my pleasure to introduce a pretty powerful woman, Barbara F. Berenson. Barbara is the author of Massachusetts in Women's Suffrage Movement, Revolutionary Reformers, 2018, Boston in the Civil War, Hub of the Second Revolution, 2014, and Walking Tours of Civil War Boston, Hub of Abolitionism, 2011, with a second edition in 2014. She co-authored The Breaking Barriers, The Unfinished Story of Women Lawyers and Judges, 2012. A graduate of Harvard College and Harvard Law School, Barbara retired from her position as senior attorney at the Massachusetts Supreme Judicial Court in June of 2019. Barbara, welcome.
Thank you so much. It is a pleasure to be here. Thank you so much for having me. And thank you to everybody who was attending, who was inviting us into your home. To begin my talk, I'm going to start by sharing the screen so that I can set up my PowerPoint so you can all see it. Okay, perfect. So welcome. So this particular talk, and I suspect that some of the people in the audience tonight might have heard me speak at the Worcester League of Women Voters or other talks I've given in the Worcester area. But many people were very interested when I spoke about suffrage, which of course is based on this book, where I focus on the Massachusetts story of the women's suffrage movement, but use it to highlight the national story. You know, what next? And so I decided, and I'm working, my next book actually will focus on some of the interesting women and the things they did in the years following the women's suffrage movement. To organize a talk that would bring us up to the present, I decided to use the Equal Rights Amendment as an organizing principle, because the Equal Rights Amendment, as you'll hear in a moment, began right after suffrage was achieved in 1920. So that's where I'm going to bring tonight. So just to remind you all what the Equal Rights Amendment says, many people haven't read it in a while, and of course it's not yet part of our Constitution. Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And the only reason I bothered to read it tonight, which I normally don't do, is because of the recent decision that was decided just last week, Bostock versus Clayton County, which when the Supreme Court by a vote of 6-3 held that sex in Title VII includes people who are homosexual or transgender. And so that may well impact how the word sex might be interpreted in the Equal Rights Amendment. That's something we'll come back to at the very end or perhaps during Q&A, but I just wanted to flag that for your attention since it is such breaking news. So to begin the story, we're going to go back to the end of the suffrage movement. Some of you, of course, are well-grounded in the suffrage movement, some of you less so, and I can't ask for a show of hands, so I will just plunge right in. The final years of the suffrage movement were marked by a dispute within the suffrage movement between the National American Women's Suffrage Association, which was the large, dominant, more mainstream women's suffrage association that had worked for decades and decades, and a new upstart organization, the National Women's Party. The National Women's Party was led by Alice Paul. The League of Women Voters begins in 1920 when women's suffrage is achieved, and Maud Wood Park, who had been the chief lobbyist for the National American Women's Suffrage Association, takes the helm of the League of Women Voters. The rivalry between NASA, the National American Women's Suffrage Association, now the League of Women Voters, and the National Women's Party continued, however. The initial rivalry was based on matters of style and tactics primarily, because Maud Wood Park and NASA believed in constant agitation, persuasion, education. They lobbied very hard. They played hardball politics, but they did not do the kinds of things that Alice Paul wanted to do. In her words, deeds, not words. And these are the women that picketed in front of the White House, for example, and when they were arrested, went on hunger strikes. It turns out that both kinds of tactics were critical to success in achieving suffrage. But this rivalry that developed in the 19 teens continued beyond. And part of the reason it continued beyond is that after 1920, Alice Paul favored an Equal Rights Amendment, but Maud Wood Park, the League of Women Voters, and nearly every other women's organization did not. And the reason for that comes out of a very conservative era in Supreme Court history. During the years in the 1900 to 1920 and beyond, really up to 1937, the Supreme Court struck down virtually any attempts to regulate working conditions, hours, minimum wage, overtime pay, and so forth. And the singular exception was a victory that attorney Louis Brandeis won in 1908 in the case of Muller versus Oregon. This is before, of course, Brandeis becomes a justice of the US Supreme Court. And in Muller versus Oregon, Brandeis was able to persuade the Supreme Court to defend, to uphold an Oregon law that limited women to working 10-hour days, which sounds like a lot to us, but compared to what they had been doing, it was a huge achievement. And his argument that the court accepted was the importance of protecting women because they would become mothers, because of their capacity for childbearing. This was called protective legislation. And it was the only protection that women had in the workplace. So they did not want to lose it, which meant that the League of Women Voters and virtually every other women's organization opposed Alice Paul when she initiated an Equal Rights Amendment. One of Alice Paul's closest allies was a woman named Doris Stevens, and she complained that any kind of protective laws are roadblocks to equality. But the other side, the allies of Maud Wood Park, Florence Kelley, who was a leading consumer advocate in New York, Rose Schneiderman, who was a labor organizer, took issue with that. And they said, for example, and I'm just going to read you a brief quote from Rose Schneiderman. She said, "I dare say that if the woman supporting the ERA had to sort dirty linen instead of sitting in a nice, airy office, and if she then had to go home and get her own dinner, wash and mend clothes, and take care of 2 or 3 children, she would be ready to be protected by legislation." So the Equal Rights Amendment did not advance during the 1920. The League of Women's Voter view prevailed. But there were some very other important issues that women worked on behalf of during the 1920s. One was a bill to give aid to mothers and children, which was a high priority because of the tremendously high rate of maternity death and infant death. If you look at these statistics, you'll see, amazingly, 33% of children died within the first 5 years of their life in 1921. The Shepard-Chowner Act, which was supported by these variety of women's organizations, a law allowed federal grants to be given to states to use for children's health programs. So that was enacted in 1921. In 1924, the League of Women Voters and other women's organizations were critical in persuading Congress to propose a child labor amendment. If you haven't heard of it, that's because, for reasons we'll discuss in just a moment, it was never ratified by 3/4 of the states. But nonetheless, the fact that it was proposed was a huge victory. However, opposition hadn't gone away. And if you've been to my talks or read about the suffrage movement, you know how vociferous the anti-suffragists were. And they remained active even after 1920. So opposition to these laws that I just mentioned included the Woman Patriot Corporation, which was the new name for the Anti-Suffrage Association. And you can see here they're in their masthead, dedicated to the defense of woman, motherhood, the family against suffragism, feminism, and socialism, always associating women's rights with socialism or communism. The American Medical Association, which viewed these grants that I mentioned as the first step to socialized medicine, the Catholic Church, states' rights advocates, and a number of other groups. So how did this legislation pass despite that? And the answer is because there was tremendous fear by politicians that there would be a woman's bloc. If they didn't do some of these things that women asked, that women would turn around and vote them out of office. But as you all know, that didn't come to pass because even today, there's not that much of a woman's vote, which we'll talk about at the end of the talk. And the result was that the successes of the 1920s disappeared very quickly. The Shepherd-Towner Act lasted throughout most of the decade, but sunsetted at the end of the 1920s, and the Child Labor Amendment failed to be ratified. And that's because politicians came to realize that they didn't need to fear, or at least not back then, a woman's vote. So that's a very, very quick introduction, but I only have about 40 minutes to the 1920s. And by the way, as you're writing questions in the chat room, I encourage you to also have questions that don't necessarily pertain to things that I talked about, but that are things that I have to skip over tonight. So now we're going to turn to the heart of the Equal Rights Amendment movement, which is, of course, the 1970s. So a few milestones on our way there. The Fair Labor Standards Act is part of the New Deal signed by President Franklin Roosevelt in 1938, and that allowed things like regulation of hours and overtime pay. And that meant that women became less concerned about the necessity of protective legislation because some of these legislative initiatives now applied to men and to women equally. Rosie the Riveter, wartime, World War II, like every war in American history, has at the same time as it's brought much tragedy to the country, also brought new opportunities for women. The birth control pill in 1960, which gave women more control, of course, over their own reproductive function than they had ever had previously. The civil rights movement, this is a picture of Rosa Parks in the 1950s, and that's very important, not only because women were very involved in the civil rights movement, but historically, women's rights activism also trails very slightly activism by other groups in American history. So for instance, the whole women's suffrage movement grew out of the anti-slavery or abolitionist movement. And similarly, the civil rights movement of the 1950s and 1960s propelled forward activism on behalf of women's rights. When John Kennedy was elected president in 1960, he was persuaded by some of the women who had supported his campaign, including Eleanor Roosevelt, to appoint for the first time ever a commission on the status of women. A key figure on that commission was attorney Pauli Murray. And she's very important because she was one of the early people that developed the notion that one could use the 14th Amendment's Equal Protection Clause on behalf of gender discrimination as well as racial discrimination. She called it combating Jane Crow as well as combating Jim Crow. The Equal Pay Act of 1963 was a singular achievement of the Kennedy administration. Huge progress for women, but like all progress, limited, because what the Equal Pay Act of 1963 did was promise equal pay for men and women who held the exact same job, the same title, the same responsibilities. So it did nothing to address the inequities in so-called pink ghettos, the sorts of jobs that women tended to hold in the workforce. Also in 1963, Betty Friedan published her manifesto, The Feminine Mystique, in which she identified, really focusing, as you probably all know, on white, middle and upper class, educated women, the dissatisfaction that so many of them, she said, experienced, which turned out to be true because so many people immediately identified with it, of women, as she said, who were slaves to their homes, their husbands, their children, and their appliances. And Betty Friedan would very quickly emerge as a leader in the new women's rights movement. The Civil Rights Act of 1964 was a huge turning point. That's the law that enacted Title VII, the one I mentioned at the beginning, and the definition of sex. And Title VII, as I'm sure you all know, prohibits discrimination by covered employers on the basis of race, color, religion, sex, or national origin. The Equal Employment Opportunity Commission was established to address complaints brought under Title VII. But the Equal Employment Opportunity Commission largely ignored claims that were brought alleging sex discrimination and chose to focus instead on complaints primarily on race or national origin discrimination. And that led in 1966, a group of women activists, including Pauli Murray, including Betty Friedan and others, to come together and form a brand new organization called the National Organization for Women. And I do just want to point out its name for a moment, even though this founding convention, this founding board that you're seeing here shows all women, they very purposefully chose the name National Organization for Women, not National Organization of Women, because they understood that they needed male supporters and the importance of alliances. Now issued a statement of purposes calling for equal partnership of the sexes, and a Bill of Rights. And in the Bill of Rights, and you can look at it here, very significantly, number 1 was an equal rights constitutional amendment. In other words, a revival of what Alice Paul had first pushed for in the 1920s, and which had been very unpopular then, had sort of percolated along during the past few decades. Alice Paul, who was still alive, continued to march to Congress every year to reintroduce it. But now what would become a new, very important organization backed the Equal Rights Amendment. Another very important thing that NOW did is NOW set out to persuade women, and if you look at the bottom of this slide, that the concerns that they felt, the struggles they had over childcare, lack of education, unequal access to jobs, and so forth, were not their own individual problem to solve, but they were societal issues that needed to be addressed together by society. At the same time as NOW was forming, somewhat similarly to the NASA National Women's Party divide back in the 19-teens, you had a little bit of a generational divide. So a lot of young women, while they supported what was happening in NOW and elsewhere, also wanted to take matters into their own hands and wanted to get what turned out to be very important public attention. So this is just one example, a famous example of protests outside the Miss America pageant in 1968. Shirley Chisholm, an African-American woman elected to Congress in 1968, introduced the Equal Rights Amendment in a speech she gave in May of 1969. And she said that men and women equally need equal rights, that women don't need any protection that men do not need. What everybody needs are laws that protect working people and that guarantee them equal rights. 1970, August 26th, is a significant day. And if you think about it, many of you might recognize that August 26, 1970 was the 50th anniversary of the day that the Women's Suffrage Amendment was added to the Constitution. And certainly it's pause to think about how in the midst of this pandemic, we may be commemorating August 26, 2020 in a couple of months. Betty Friedan proposed that that anniversary be commemorated with a women's strike for equality. And women went on strike, had parades all across the nation, particularly in big cities, for a number of causes listed here, but very fundamentally, very critically, for the Equal Rights Amendment. Also very critically, for the right to abortion. The right to control one's reproductive health had become very much a focal point of the women's movement. Gloria Steinem emerges on the scene and becomes a major leader, as you all know. She is the publisher, of course, of Ms. Magazine, and this is its iconic cover of its first issue, showing Wonder Woman running for president. Showing how much culture had changed, how much the women's movement had penetrated into American culture, the Mary Tyler Moore Show premiered in September 1970. And while if you've ever seen it on reruns in the last 20 or so years, it's hopelessly dated, it was revolutionary, of course, when it began, because Mary Tyler Moore lived on her own, working at a job without the constant support of a father or a boyfriend or a husband. 1972, the Equal Rights Amendment was proposed by Congress. And the way it works to amend the Constitution, an amendment has to be proposed by Congress, and then it has to be ratified by 3/4 of the states. So in 1972, Congress, by overwhelming bipartisan margins, if you look at these numbers, 354 to 23, and in the Senate, 84 to 8. I mean, it's hard for us as we sit here in 2020 to remember an era like that. But in 1972, partly shepherded brilliantly through the House by Martha Griffiths, a congresswoman from Michigan, the House and Senate both approved the Equal Rights Amendment and sent it off to the states to be ratified. 22 states ratified it so quickly in that first year in 1972. This is also an era of intersectionality, although that word had not yet been coined. And backing the ERA and working in alliance with them were minority women who had both separate organizations and organizations that were primarily white. Also, gay organizations. So the umbrella tent of the women's rights movement had really grown and become quite broad and encompassing, even if some people felt that they weren't fully equal members of that tent. But at the same time as that was happening and wonderful progress was being made, Phyllis Schlafly appears on the scene. If we were in person, I would be able to ask you how many of you have seen the recent series, Mrs. America, which of course focuses on Phyllis Schlafly. I imagine some of you might have. But Phyllis Schlafly emerges as the face of the anti-ERA forces. And her organization, her organization was the Eagle Forum, but Stop ERA, I'm sure many of you are familiar with those signs, and you can see one in the slide. The STOP was actually an acronym, and the acronym was Stop Taking Our Privileges. And in my mind, what she said was that feminism was an attack on women rather than a defense of women. In my mind, that harkens directly back to the women's suffrage movement. The notion that women were going to lose all sorts of privileges of love, of marriage, of home, and children, and that after suffrage on a cartoon like this, they would confront only strife, anxiety, and loneliness. And Phyllis Schlafly essentially repackaged these same arguments for the 1970s. Ruth Bader Ginsburg in 1971, speaking out about this, said that the pedestal of privilege upon which women have been placed has all too often, upon closer inspection, been revealed to be a cage. And again, that made me think of one of my favorite suffrage cartoons, when Blanche Ames of Massachusetts drew this cartoon to mock the anti-suffragists who said they were so content on their pedestal, and to show that their pedestal was emptiness. There's an anti-suffragist there with Dodo and Fido, while it's the suffragists who also are women and mothers who are the mainstay and the ones who are really working on behalf of women's rights. So as I mentioned, the ratification of the Equal Rights Amendment started off very fast. 1972, 22 states ratified it. 1973, 8 more states ratified it. I'm sure you may recognize this figure here in this slide, Bella Abzug, a congresswoman and a huge organizer on behalf of women's rights and a major proponent of the Equal Rights Amendment. That same year, 1973, is also the year when the US Supreme Court issued its opinion in Roe versus Wade, upholding a woman's right to abortion under the 14th Amendment of the Constitution. That was a wonderful victory for women who sought reproductive rights and protection in the Constitution, but it also energized the anti-ERA forces, and there was a joining of issues. So the Stop ERA and the anti-abortion forces merged together, and from then really till now, as we'll talk about when we get to 2020, these two issues have been largely merged in the public mind, and certainly merged in the people that oppose the Equal Rights Amendment. The pro-ERA forces also joined issues together, although a little less dogmatically, a little more sense that the issues are somewhat distinguishable. But the same forces that supported the Equal Rights Amendment also tended to support a large, a number of other requests, including, very importantly, the right to an abortion. As a result of Phyllis Schlafly's work and her allies, ERA ratification began to slow to a crawl. And you can see here that after the successes of 1972 and 1973, you only have 5 more states in 1974 through 1977. And making matters even worse, 5 states that had ratified the Equal Rights Amendment voted to rescind the ratification. The issue of whether or not a state can rescind an amendment once ratified is something that remains unclear. I think the prevailing wisdom is that a state cannot do so, but there are many who would quarrel with that assessment. So the Equal Rights Amendment fell upon hard times. Alice Paul dies in August of 1977, and there is a memorial march for her on the suffrage anniversary on August 26th, a huge march in Washington, D.C. to once again propel forward a movement for the Equal Rights Amendment. There was a large conference held in Houston, Texas in November 1977, and the ERA deadline is extended. Now, I didn't yet mention the deadline, I waited till now, but unusually for a constitutional amendment, when the Equal Rights Amendment was proposed by Congress, rather than simply proposing it and saying, now states go and ratify it, Congress attached in a preamble, not to the text of the amendment, but to the enabling legislation itself, a deadline, saying that ratification had to be completed by 1979 in only 7 years. And at this conference in Houston, the deadline was extended another several years, which of course its advocates hoped and thought would be adequate. The picture on the left shows how in this how widespread and how across party lines support for the Equal Rights Amendment was, since you have here Lady Bird Johnson, Rosalind Carter, and Betty Ford all present. At the same time as that convention was happening in Houston, also in Texas, there was a counter-conference and protest of Phyllis Schlafly and her supporters. Jerry Falwell appears on the scene at about the same time as Ronald Reagan is running for president. And when President Reagan is elected in 1980, or in the platform when he was nominated, the Republican Party drops its support for the Equal Rights Amendment. And for the past 40 years, the Republican Party has, with some very notable exceptions, largely been a party that does not support the Equal Rights Amendment. And Jerry Falwell said that we must rise up against the tide of permissiveness and moral decay. And one of the things they said was causing moral decay was things like women advocating for the Equal Rights Amendment. At the same time as that is happening, and this is not a lecture on the law, even though I would be delighted to talk about that at some point, much progress was being made on behalf of women, as you all know, in the courts, driven by a number of people, but most singularly by these 2 women. Ruth Bader Ginsburg on the left as an attorney who brilliantly argued many cases opposing sex discrimination before the court. And on the right, of course, Sandra Day O'Connor, the first woman appointed to the US Supreme Court. Although moderate and sometimes conservative on a number of areas of law, she was a strong advocate for women's rights. And what Ruth Bader Ginsburg, picking up what I mentioned earlier in one of my comments about Pauli Murray, was argue that sex equality could be inferred from the Equal Protection Clause of the 14th Amendment. And a number of laws discriminating against women were struck down by the United States Supreme Court. During Q&A, you certainly are free to ask about that, but one of the things that opens up, of course, is some uncertainty in the eyes of many as to what the Equal Rights Amendment would accomplish, and the question that's often asked of, do we still need it? I'm going to argue we do still need it, but it is a fair point and a question that many people ask. So now we're going to jump from that era up to where we are today in these last few minutes before the Q&A. So just a few milestones as we go from 1980 up to the present. We have, of course, in 1984, Geraldine Ferraro, the first woman to be a candidate on a major party ticket. She, of course, was the vice presidential nominee with the ticket headed up by Walter Mondale. 1991, Anita Hill testifying about Clarence Thomas when he was nominated for the US Supreme Court, which in addition to making a name for herself as a stalwart defender of women's rights, brought the issue of sexual harassment to the nation's attention. 2007, Nancy Pelosi becomes Speaker of the House for the first time, the first ever woman speaker. 2016, of course, the Democratic Party nominating a woman, Hillary Clinton, to head the ticket. Following the election of Donald Trump, we have the Women's March in January of 2017, the Me Too movement of the last several years. During the midterm elections of 2018, brought a large number of women to Congress, and this is them at a State of the Union address, wearing many of them suffrage white. But of course, just like in the 1920s, it's essential to always remember that women are not monolithic, and historically, women do not generally vote very much as a bloc, although that has begun to shift just a little bit in the last couple of decades. And so if you look, for instance, and just to make it simple for this talk, I just pulled up the results statistically from the last presidential election in 2016. And Hillary Clinton did win substantially more women's votes. But if you look over here on the right side, you'll see that among white women, the split between Donald Trump and Hillary Clinton was actually very close. And it was non-white women that's responsible for the fact that Hillary Clinton had substantially more votes from women than Donald Trump. So today, where we sit in 2020, there is a new focus on the Equal Rights Amendment, and there's actually a lawsuit, a motion to dismiss on a lawsuit that's going to be argued in federal district court here in Massachusetts tomorrow. So how did that come to be, and why now? As to why now, I think it is because in the last few years, with new appointments to the United States Supreme Court, there's been a sense on the part of many that just like the court can give rights, the courts can take away rights. And unless and until there's a constitutional amendment mandating equality for women, there's the possible fear that the victories that were won back in the 1970s, 1980s, and so forth are vulnerable. This is from Saturday Night Live, not long ago, instructing Ruth Bader Ginsburg on what she should do. And of course, this is the Supreme Court today. So where the ERA status is, as we sit here today, is Carolyn Maloney, a congresswoman from New York, very presciently in 2012 wrote a letter to the archivist saying, what would happen if now 3 more states ratified the Equal Rights Amendment? Because when we left the story at the end of the 1970s, 35 of the necessary 38 states had ratified the Equal Rights Amendment. And then not a lot of attention by most people. I mean, some people, of course, did. But by and large, a lot of people did not pay the Equal Rights Amendment a lot of attention for the next 30 plus years. And Carolyn Maloney raised this issue, asking the archivist, what would happen if 3 more states ratified? And he wrote back and said, if 38 states ratified, then my job is to add the Equal Rights Amendment to the United States Constitution. After the election of Donald Trump, a number of people worked together in several states to gain ratification. As you can see here, and you may know this, 3 states, Nevada, Illinois, and Virginia, all ratified the Equal Rights Amendment in the last 3 years, bringing the total to 38. Now what? Meanwhile, the National Commission on Military, National, and Public Service, just a few months ago, but it was kind of buried in the pandemic news, held that the selective service system should continue, but that they saw no reason why women as well as men should not be required to register for the selective service draft. And that, of course, was one of the few remaining arguments, substantive arguments of the anti-ERA forces, is that women would be subject to a potential draft. And here we had this commission saying, while there is, of course, no draft now, we have an all-volunteer army or all-volunteer military, that women ought as well to have to register. So where we are now is the Trump administration, his Office of Legal Counsel, told the archivist that the ERA, despite the ratification of these additional 3 states, had expired because of the deadline, and that therefore it should not be added to the United States Constitution, and so therefore it has not been added. As a result of that, 2 different lawsuits have been passed. There's also been action in Congress. As for the action in Congress, the House passed legislation removing the deadline, saying that the deadline was invalid. That has not yet passed in the Senate. And of course, it won't pass in the Senate unless the Senate changes in the next election. However, 2 lawsuits have been filed. One lawsuit has been filed in the district in DC, Washington, DC court, are brought by the attorney generals of the 3 states that have just ratified, saying, we ratified, add the ERA to the Constitution. And the other lawsuit has been brought here in Massachusetts on behalf of 2 nonprofit organizations, as well as an individual woman. That's the one that will be argued tomorrow, claiming that the ERA has also been ratified and must be added to the Constitution. In both these cases, motions to dismiss have been filed. And as I mentioned, actually at 11 a.m. tomorrow, a hearing on the motion to dismiss in the Massachusetts case will be heard. So in terms of what's next, there will be continued efforts to remove the deadline. These court cases will percolate through the system. I don't like to give predictions about what the court may do. I've been a lawyer for too long and realize that predictions can always be wrong. But I find it very hard to feel optimistic that court challenges, as much as the lawyers, the lawyer who's arguing the case tomorrow in Massachusetts is actually a dear friend. But it certainly seems a long shot to think that the court is going to both look past the deadline and look past the rescissions, but we will of course see what happens. We also have no idea what the impacts of the current protests and mobilization across the country may be. And you may think that these issues are totally unrelated: Black Lives Matters, protests against police, and the Equal Rights Amendment. And on one hand, they are. On the other hand, as I mentioned earlier, women's activism has historically followed periods of activism on other fronts. And so I do wonder if there may be some manifestation there. And then, of course, we are heading into what will be a very consequential presidential election. So even though the ERA has kind of seemed on the back burner for much of these last years, it's very much back on the front burner today. What I'm going to do now is I really want to hear from all of you. So I am going to stop, even though I could go on for hours, and hope that you have typed into chat some questions that I can answer. And feel free, of course, to continue typing away. And thank you so much for attending and listening.
I did receive some offline questions to share with you, and I'm going to start, and thank you for this, and I will continue to draw in other questions through the chat box. So the first question is, as a woman and a historian, is it troubling to you that many young women have been unfamiliar with the long-term fight for ERA ratification and remain complacent? And what can change this?
That's an excellent question. So of course, I mean, as somebody who loves history and as a historian, I'm always disappointed when people don't appreciate history, because understanding history is so critical, not only to understanding how we got here, but also to understanding how difficult change is. You know, I get very frustrated sometimes with people who think in terms of 2 years or 4 years or 8 years to make change. And if, for example, you look at the women's suffrage movement, you realize that it was nearly a century of constant work and constant campaigning. And so I think having a historical perspective and understanding history is critical. In terms of complacency, I'm of two minds. And I myself have a daughter who's 26, although happily she does like history. On the one hand, it's wonderful that so many young women can grow up and feel that there are so many opportunities to them, that they can feel complacent, that they feel so close to equal. But I think it's so important for them to realize, and usually they do at some point realize, how inequitable things remain, because soon they will confront, if not explicit harassment or discrimination or bias, implicit. And the difficulties and the challenges. And just today, I think it was today or yesterday, I was reading yet another article in the newspaper about how the pandemic is hurting women in their careers much more than men, because women are the ones who are at home, often trying to juggle primary responsibility for children who aren't at school or daycare. So I think it's just so important that young women understand that they are part of that they stand on the shoulders of women who worked so hard for change, and really it's their obligation to continue to make more change and to march forward. And so I would love that message to go out.
Thank you. Another question that I had received is, let's see, Justice Ruth Bader Ginsburg has recently stated that the ERA movement should start all over. What would that look like, and when might that be? Another 50 years? What are your thoughts about that?
So that is another excellent question. So Ruth Bader Ginsburg, of course, has been a strong proponent of the Equal Rights Amendment. She continues to talk about it. One of the things she often says is how much she wishes, and she pulls out the little constitution that she carries around with her, I think, everywhere she goes, and says that she would love to be able to show her grandchildren and other young women that, see, here in the Constitution, it says that women are equal to men. So certainly she has been a stalwart advocate. I think Ruth Bader Ginsburg made the comment that you quoted. I think it was at Georgetown Law School, but it's some talk relatively recently. And I think that what she was probably expressing, and certainly some people were critical of it because she will be sitting on the court that decides some of these issues, the sense that if the ERA is to be adopted to the Constitution, it would be wonderful if there was widespread public sentiment behind it. I don't believe that she was tipping her hand about what a court ruling would look like. I don't think she would ever do that. But I think what she was saying is that after all this struggle, all these years, she doesn't really want this to hinge on a 5-4 split by the court, evaluating, for example, the legitimacy of the deadline, and that she would probably rather see a movement, a groundswell across the board support for the Equal Rights Amendment. Because one of the other things I didn't mention, another legal issue that I'm sure she is thinking about, is that there is an understood standard in the law, in constitutional law, that ratification should be, quote unquote, contemporaneous with proposal. Now, some amendments have been ratified 200 years after they were first proposed, and this is only 50 years. But nonetheless, that's another argument that opponents would make. So I interpreted personally Ruth Bader Ginsburg's comments as sort of I don't really want the courts to have to resolve this. I would like there to be a movement on behalf of the Equal Rights Amendment again.
Thank you. Let's see, we have an important question from, let's see, Jacqueline, I believe it is, who asks, did racism impede or propel the suffrage movement?
So that's really a question about the suffrage movement. That's a very long, complicated question. And I sort of want to refer you to one of my suffrage talks or my suffrage books. But the short answer is that the women's suffrage movement, particularly in the women's suffrage movement started off as the stepchild of the abolitionist movement. So the early suffragists, if we go back to Seneca Falls and the years around the Civil War, were all advocates of the anti-slavery movement as well as the young women's rights movement. But ultimately, by the time the Women's Suffrage Amendment is passed and ratified in 1920, the women's suffrage movement had made whatever compromises were necessary to succeed. And in addition to the own racism in the hearts of a number of suffragists, that meant a compromise to get support from white Southerners, which they needed. And that compromise was essentially to say the 19th Amendment is about gender and gender only, and we take no position on race. In other words, the message they were saying is, please ratify the amendment so that women can vote. And then if you turn around in the South and disenfranchise African-American women the same way you have disenfranchised African-American men, that is okay.
Thank you. Let's see, another question that I received is, are there concerns around equity and inclusion, even with the ERA?
Well, I think that question, I'm trying to sort of understand where it's coming from. I think that one of the things that question is asking is, what would the ERA do? The ERA, nothing changes hearts and minds until hearts and minds are able to be changed. It's a two-way street. The law can help change hearts and minds can help change the laws, but passing a law is not enough. So in terms of stereotypes that denigrate woman, and how how women are treated by many men in our society, and private personal life and things like that. I mean, that takes more than a constitutional amendment to change. I mean, a lot of progress has been made, but there's a long, long way to go. Because, of course, the Equal Rights Amendment would only address laws of governments. I mean, it's an amendment geared toward government action, not private personal action. In terms of what the Equal Rights Amendment would actually do, that's also something where wise people reasonably disagree, because the Equal Rights Amendment is sufficiently vague that it will need to be interpreted by courts. And if you look, for example, at the 25 or so states that have state equal rights amendments, you can see that in some states the Equal Rights Amendment allow A, but in other states they don't. So there is no one uniform way. I think one thing that would be clear under the Equal Rights Amendment is that egregious incidents of laws that discriminate clearly against women would be struck down. But one might argue that that's already happened under the Equal Protection Clause. And so I think that one of the things, and this may be why, just going back to Ruth Bader Ginsburg, why she sometimes talks about wishing that she could pull out a constitution and say, see here, women are equal to men, is because one of the very powerful aspects of the Equal Rights Amendment is its symbolism. It's what it means. It's trying to shift hearts and minds. And that is often a very effective way to explain it, since until courts litigate it, we don't precisely know what the outcome will be. I'm sorry if that was a little too lawyerly, but...
Yes, thank you. Thank you for that. Our program is drawing to a close, but I do have one other question that came through, and that is, would you please speak to the original intent of Title IX regarding gender equity and some further gains because of it?
Well, I'm not a scholar of Title IX. I mean, the original intent of Title IX, which I think is still what we accept today, is that Title IX, which was legislation passed in the 1970s, requires equity in any educational institution that receives federal funding. And the way in which Title IX has been most widely recognized and perhaps even utilized has been in athletics. And any of you who didn't get to play sports in high school or college, but have daughters or granddaughters who get to, it's thanks to Title IX that we have equity in sports, or it does, it's not 100% equity, but what is essentially equity in terms of access to athletic opportunities. And so many people mistakenly think that Title IX was an athletic law. It isn't. It's about equality in education when there's federal funding involved. So Title IX has also been used, for example, to do things like bar sexual harassment and sexual assault at universities. And many of the cases that you might read about in the newspaper, when there are women claiming that their assaulter is allowed to attend class rather than being barred from campus and so forth, following an allegation or even a determination of a sexual assault, are also actually cases brought under Title IX.
Well, I'd like to thank our audience for privately and publicly feeding questions to me for Barbara this evening. Barbara, thank you so much. And at this point, I would like to present and introduce Ginger Novickis, a board member of League of Women Voters of Worcester area.
Well, thank you, Barbara. It was such a dynamic presentation and so important. So, as Barbara has referenced, the League has long been a strong and active supporter for the ratification of the Equal Rights Amendment, both nationally and locally. And our motto, reflected in our mission, is empowering voters, defending democracy. The League of Women Voters, a nonpartisan political organization, encourages informed and active participation in government, works to increase understanding of major public policy issues, and influences public policy through education and advocacy. This is our plug. So what exactly do we do? What does the League accommodate when we are talking about our mission? We encourage active and informed participation in government federal, state, and local. We work to increase understanding for major public policy issues, and we seek to influence public policy through education and advocacy. We neither support nor oppose any political party or candidate for elective office, but we do take positions on matters of public policy. The League of Women Voters of the Worcester area invites all members of the community to consider membership in this vital organization, and thanks you for being here tonight.
Ginger, thank you. Barbara, thank you. On behalf of the museum's Pretty Powerful Organizing Committee, the Costumes and Textiles Council, board, and staff, we thank you for joining us, as well as the audience for joining us at this event. We're grateful to our speaker, Barbara Berenson, for an informative presentation. And it is now my pleasure to introduce Bill Wallace, Executive Director of Worcester Historical Museum. Bill.
Good evening, everyone, and thank you, Barbara, for another great talk. It isn't quite the same as being in the Fletcher Auditorium at 30 Elm Street, but better days are coming, and we'll see you back there. We want to thank everyone again who joined us this evening for this great conversation. It really is important to know how we got here and what it took to affect change or actually to continue the process of change. So it's really an important conversation as we look forward to celebrating the anniversary of the vote, but also facing some of the challenges that are before us in this day right now. We want to thank our sponsors, of course, and my job is to mention the Albert Rice Charitable Foundation, the Rockwell Foundation, Berkshire Bank, and again, all the members of our Pretty Powerful Organizing Committee. Our partner this evening, of course, Ginger, and our friends at the League of Women Voters, but also the Massachusetts Cultural Council, which we all know is so very important to our understanding of who we are, where we're going, and what this commonwealth, 2 words, lowercase letters, will be as we redefine a new future for not only ourselves as individuals, but our businesses, our organizations, and our understanding of who we are. So we hope that all of you this evening will stay in touch with us. We're looking forward to lots of great partnership programs as Pretty Powerful and the anniversary continue. There'll be notices on our website, our Facebook page, our social media, as I'm sure there will be many other organizations. And fairly soon, as we get this program negotiated, it will be available on a YouTube channel, and we'll send you all a notice. So in the meantime, yes, let's all learn more about how we got here, what we're doing, and how we're going to get there in the future. Thank you.